Well, good evening, everybody. I recently posted a link to this New South Wales Industrial Relations Commission decision, Inspector Spence versus Kai, which is a prosecution under New South Wales Occupational Safety and Health legislation. It caught my attention because it was one of those cases that again looks at the concept of our documented safety management systems and whether they're simply paper systems or actually effective to control risks. Now, some of you probably haven't had a chance to grab hold of the decision and have a read of it, so I thought I'd just throw together this short blog, this short video, just to have a quick review of some of the content. As always, there's a disclaimer that comes with this. This is not specific to your own circumstances, it's just a general review of the case, some of the legal aspects that fall out of it and some of the impacts that it has for safety management. Again, it is not legal advice. If there's anything that falls out of this case that you're particularly concerned about or specific to your circumstances, then obviously you should go and get some advice about how it might be impacting on your business. The Kai decision, in my view, carries on this long tradition we have in safety and health management and safety and health prosecutions, where we have documented safety management systems that are in place and are designed to control the health and safety risks in the business, but those systems are simply not implemented. Now, those sorts of failures are evident, not just in prosecutions of small businesses in local jurisdictions, but most major inquiries around the world find these sorts of failures in safety management systems. And so if we look at the Royal Commission into the SA Longford gas plant explosion, the Royal Commission there said that reliance on the safety management system was misplaced, and the accident itself and then the subsequent inquiry obviously demonstrated that important components of the system were either defective or not implemented. And it's frightening in one sense and frustrating in another how often this is the case in so many organisations where we put so much time and effort into the development of paper-based safety management systems to control risks in the business, and then it just seems on the surface of it that nobody is actually putting any time or effort into assuring that those systems are in place and actually being complied with. And I'm not talking here about some concepts around safety culture or leadership or commitment. I'm talking about very basic, superficial, simple checking that elements of the system that we say we've either created or we've implemented or we've made available are actually created, implemented and available. Another interesting example of this phenomenon of systems developed but not implemented was a coronial inquiry, colloquially referred to as the Captain Tom. It involved the death of 2 workers in a confined space incident on a marine vessel called the Captain Tom. The coroner in that case made the observation, she said that there was no doubt in her mind that the tragedy wouldn't have occurred, these fatalities wouldn't have occurred had the Australian standard on confined spaces been complied with. What makes it interesting is the link between the non-compliance with the standard, the company's policies and procedures, and the consequences that followed. Because what the the coroner did in that case was actually prefer manslaughter charges against the operations manager involved in that incident, and she said that there's a whole range of stuff based on what's come out of this inquest that I think would be admissible as evidence in a manslaughter charge. And one of the things in the context of this case, one of the things most interesting was that she said the company and the operations manager were aware or ought to be aware of the existence of the Australian standard, which she said, if it had been complied with, would have prevented the tragedy. But relevantly in the context of what we're talking about today, that standard was in the operations manual library of the 2001, which was the name of one of the vessels. So in other words, this standard formed part of the company's policies and procedures. It formed part of the documented safety management system, and it wasn't implemented. And the failure of implementation, not only in the view of the coroner, led to two preventable fatalities, but was sufficient disregard, if you like, to give rise to potential manslaughter charges. If we look then to the context of this specific case, the Kai case, it was a construction site. A worker fell over 3.5 metres through an open, unsecured space and suffered serious head injuries. As a consequence of the accident, there were multiple prosecutions, so a number of parties were prosecuted. And Mr. Kai, who was the project manager, was in fact the 5th prosecution that came out of this series of events. He was ultimately prosecuted in the Industrial Relations Commission of New South Wales. He was convicted under Section 10 of the Act, Occupational Health and Safety Act 2000 in New South Wales, and he received a $12,500 fine. Just to give it some context again, the Section 10, so the section under which the prosecution was brought, was in relation to a person who had control of a work premises, and there was no real dispute about that. Mr. Kai was found to have control of the premises, even though he wasn't there on a day-to-day basis and he wasn't there on the day of the accident. He was in fact contracted to project manage this job and sat in an office removed from the site, and he visited the site from time to time. So in the context, again, of the case and what we're talking about, documented systems, there was a plan. It was described in the agreed facts as relatively comprehensive, and most safety management plans are, but as we see in case after case, it was defective in a number of respects. And so, for example, the plan itself referred to an occupational health and safety coordinator, two-way radios, a site shed, none of which existed. So again, this is not a case about poor implementation or poor planning or poor leadership. These things just didn't exist. And I'm dealing with a number of matters at the moment where clients are representing themselves as doing the right thing by safety because they've got these big safety management plans, and when you actually go and dig deep into them, most of the critical elements that should be in place, they simply don't exist, and nobody's aware that they don't exist. And it's almost compelling to come to the conclusion that nobody's ever read these things. What's interesting, though, is that the criticisms itself don't go directly to the cause of the incident. What they go to is a failure of doing everything reasonably practicable, a failure of management. And so the plans get held up, quite simply, by the courts and tribunals being able to say, if you as a manager were doing your job, you would be aware that there were these gaps in the safety management system, and you weren't aware and these things didn't exist. Therefore, it's quite easy for a court to draw the conclusion that as an organisation you weren't discharging your responsibilities as an organisation or as an individual, and in particular that you weren't doing everything reasonably practicable to ensure people weren't exposed to hazards. So the court went on to list some other examples of what was missing in the case of this plan. And they identified things that, relevant forms dealing with site inductions weren't completed. The particular worker who was injured in this accident hadn't completed the induction. There was a risk assessment that was dated 2004. Items in that risk assessment hadn't been implemented or followed. Reports and registers that were required to be kept as part of that weren't kept. Subcontractors had submitted safe work method statements, but these weren't being followed. And more importantly, the principal who'd engaged the subcontractors, weren't using these plans to monitor subcontractor performance. They weren't being held accountable to the plans. And there were no, in terms of instruction, the court found there was no consultation. Toolbox talks that were meant to be held under the plans weren't being held. And so just a raft of items that were meant to occur under this safety management plan, under this documented system, simply weren't occurring. The court in the Kai decision actually drew from one of the earlier findings from one of the other 4 prosecutions and agreed with those findings and said that that applied in this case. So that these matters, and a number of them were the matters I referred to in the last slide, showed that various procedures formulated by a whole range of entities on the site weren't implemented, and at best there was partial implementation of some of those procedures. Again, it makes it very easy in the context of a prosecution to demonstrate that you're not doing everything you ought to do if your own plans aren't being implemented. But leaving aside the legal side for a moment, over and above all of that, just from a safety management perspective, if these plans are the things we say are what we need to do to manage health and safety risks on site, and we're not doing them, then by logical and immediate implication, safety is not being managed. So I would have thought, from a health and safety professional's point of view, it is almost, first principles, safety management 101, that a significant part of our time should be spent going around and verifying that things we say we do in our planned processes to manage health and safety risks in our business are actually being done. Now, I know this sounds like a broken record, and I'm sorry if you don't enjoy hearing this, but it seems to me we've been banging the same drum for 25 years without really achieving any effective move forward. So first and foremost, our documented systems have to be effective to control the health and safety risks in the business. So what we are writing down needs to be relevant to the risks in the business and needs to be sufficient to control those risks. Over and above that, our documented systems have to be capable of being implemented by those expected to implement them. Without going into it in detail here, every major inquiry into significant accidents in the last 25 years have found that our documented safety management systems are typically too complex for the people that we expect to implement them to understand. So there's an important piece of work to be done around taking these processes and making them something that's capable of being implemented. And then over and above all of that, the most critical element, which is probably the most missed element, is there has to be ongoing checking to be satisfied that these processes are being implemented as intended. And I think we sometimes get lost in the confusion of our own systems that we don't assure and check that what we say we do is actually being done. And for as long as we continue to fail to check that our systems are being implemented, we will continue to have gaps in our safety management. We will continue to create legal risk for our own businesses, and over and above that, we will continue to create safety risk for our workers. Okay, as always, if you want more information, follow the links on the page to the case, to subscribe, or for more information about who we are and what we do. Thanks very much, and good luck with your systems moving forward.